So this is a case about Tennessee's prohibition on irreversible procedures for kids for gender transition purposes. The Supreme Court granted certiorari in this case. They took the case on the question of whether the prohibition on uh, puberty blockers, hormones, and surgery for kids for gender transition purposes violates the Equal Protection Clause of the 14th Amendment. So this case is all about whether the Constitution prohibits the states from restricting kids' use of these irreversible procedures. The reason it's getting attention now is because it's fairly new. We've seen a really dramatic increase in both the overall number of kids who are accessing these procedures and especially the number of girls who are getting these procedures. That number has skyrocketed from where it was. And it was only a matter of time before this sort of elevated itself as an issue. There are a lot of lawsuits involving gender identity issues. And so, it's a consequence of this going from something that was not particularly prominent to something that is very prominent with a lot more kids affected by it and a lot more doctors engaged in the practice of providing these transition treatments. I mean, this is something that emerged from Tennessee's legislature. It was actually a bipartisan law. It was passed with both Republican and Democratic votes, and it was based on the evidence that they looked at. They looked at evidence of the risks of these procedures, evidence of the benefits. They heard from people who had had these procedures done to them and deeply regretted the irreversible changes to their bodies. They heard from doctors. They heard about the practices in Europe, where a lot of countries that were very on board with aggressive use of these procedures have now looked at the evidence and pulled back and said, we don't think that the risk is worth or that the benefit is worth the risk to kids here. We had a lot of amicus support from other states in the litigation in the courts below. And given the number of amicus briefs that were filed on the other side, I expect a lot of people will weigh in. This is an issue that a lot of people are very passionate about. Supreme Court, most of the work gets done on the briefing. The oral arguments are important, but the briefs are usually the most important part of the case. The parties have a chance to really think through their arguments, lay them out, articulate them. So we just filed our brief, and now my Solicitor General, Matt Rice, is getting ready to argue the case in the court. We don't know when it's going to be argued, but probably in December or January. And at the argument, the justices will have read all the briefs, and they'll have a chance to ask attorneys for both sides questions. So if they see something that they're concerned about, if they see a point that needs clarification, if they see some unresolved tension in the arguments, they can ask about that and give everybody a chance to explain. The arguments are also a chance for the justices to communicate with each other so they can sort of better understand what each of them is thinking and identify points where they may have agreement, they may have disagreement. So the arguments are an important part of the process. But I think if people want to understand this case, the best thing they can do is read the briefs.